Good morning, everybody, and thank you for joining the session today. So, in terms of topics today, what we're going to cover, we're going to look at the new job retention scheme as it was. We had some of the details of that come out on Friday. We're also going to look at making your workplace secure from a health and safety perspective. So, I've been joined again by my colleague Lynn, who's a partner in our health and safety team. She's going to cover those issues. A really kind of key issue as well, David Goodbrand is going to look at data privacy issues around employees returning to work. And then we've got Chris again in our construction team who's going to pick up some issues around about opening up construction sites and what developments we've had since last time we spoke. And then finally, an interesting topic on proposed changes to the law in relation to insolvency, and Sophia is going to pick that up and cover those issues for us. So that's your lineup for today. I'll kick off just by talking to you. Alan's still shaking his head about not being on mute. I don't know if anyone else can see him or if it's just me. I've just got your big smiley face on my screen, Alan. So we'll kick off on the job retention scheme and the updates that were announced on Friday. So obviously we were anticipating the update for quite a while. We'd already heard from the Chancellor that he was going to keep the scheme going until the end of October, but there was likely to be some changes to it. And finally we got a bit more detail on those changes on Friday. What I would say to you is the information that we've got so far is still fairly limited. We had the announcement itself at the press conference. The government then also published a fact sheet which sets out some of the key issues round about the proposed changes to come into effect from the 1st of July. But you will have seen, and it's I guess a date for your diaries, the 12th of June we've been told is the date that we'll get more detail on the operation of what they're effectively calling a new job retention scheme. So 12th of July, as I say, 12th of June. Key date for your diary. The other key date for your diary, and I think some of this has been missed in some of the coverage of the amendments to the scheme, is the 10th of June. Why is that a relevant date? Well, what the new rules say is that you'll only be able to put employees on furlough from the 1st of July if prior to that date they've already had a 3-week furlough period. Okay, so for those of you that are using furlough, any individual that you've placed on furlough before the 1st of July and they've already had a 3-week minimum furlough period, you will be able to put them on furlough under the new scheme from the 1st of July until the end of October. If you have any individuals who have not been placed on furlough and who haven't completed a 3-week furlough period, by the end of June, you won't be able to put them on furlough under the new scheme. So obviously 10th of June is 3 weeks before the end of June, and so really starting to think about, well, if we are going to continue to use the furlough scheme, do we need to put those individuals on furlough now to give us maximum flexibility after the 1st of July. Okay, so quite an important point, I think. The other kind of key change, and I'll come on to talk about the contribution levels, they're the ones that have sort of had most headlines, I'll come on to talk about that, but the other key change, and I think it's a very welcome change for employers, is that from the 1st of July, employees who are placed on furlough will also be able to carry out some work. All right, and obviously the government was under quite a lot of pressure there because the way the scheme works at the moment, as most of you will know, is you're either on furlough or you're at work. You can't do both. You can't work part-time. So the proposal had been that from the 1st of August, employers could place employees on part-time work and also furlough. However, that's been brought forward to the 1st of July. And I think that's possibly to reflect the move towards lockdown and the kind of roadmap that's been put in place. I don't know, some of you might have seen there's been a bit of, I suppose, a bit of an issue between the Scottish and Westminster government there, where I think Nicola Sturgeon at the press conference on Monday spoke about the changes to the furlough scheme reflect the pace at which England is coming out of lockdown, perhaps more than it reflects the pace at which Scotland is coming out of lockdown. And so the point she was making is, because we're coming out of lockdown slower, it may be that we need the furlough scheme to be extended beyond October. And that's something that she was looking to speak to the Westminster government about, or alternatively she's spoken about potentially asking the Westminster government for more budget so that if needed in Scotland, there could be an extension to the furlough scheme in Scotland. So just something to keep an eye on. But from the 1st of July, employers can have employees on furlough part-time and at work part-time. And I guess the other important point to note then is what the Chancellor said on Friday is that's the new scheme will be from the 1st of July. It will close though at the end of October. So it'll be a total of 8 months where you can place staff on furlough. What we don't have a great deal of detail on yet is how the part-time working furlough scheme is going to work. And I think that will be the detail that we'll get on the 12th of June. And I think a key issue there is how do you decide for your employees? There'll be obvious employees whose normal working hours are 9 to 5, Monday to Friday. And so if you say to them, you have to return to work for 2 days a week and you have to be placed on furlough for 3 days a week, you'll know that their furlough time is 9 to 5, Wednesday, Thursday, Friday. They'll be fairly straightforward. But many of you will have situations where you've got employees who work variable hours, perhaps work shifts, you've maybe got people on 0 hours contracts, all these different variations. And what we don't have detail on yet is how you would actually calculate or look at, well, what is that employee's normal working hours for the purposes of submitting a furlough claim. So that's something, as I say, hopefully we'll get a bit more detail on. The other thing to be aware of is you'll note at the moment that the furlough payment is 80% of salary or £2,500, whichever is the higher. So you've got that cap there of the 2,500. The fact sheet that was published on Friday makes it very clear that that £2,500 will be prorated. So if you've got someone that's coming back to work 2 days a week, then the 2,500, will be 3/5 of 2,500 per month will be the cap that will apply, if that makes sense. That all starts feeling too much like maths for me, but hopefully that all makes sense to you. So part-time, as I say, you have to have the employees have to have had a period of furlough for 3 weeks before the end of July, the end of June, before you can place them on furlough in July. The other point that's quite interesting in the fact sheet is that the fact sheet states that the employer, and I'll quote the wording to you, must agree any new flexible furloughing arrangements and confirm the agreement in writing. Okay. Now, on the face of it, that looks like that goes a bit further than the current job retention scheme. You'll remember, for those of you that have been following this closely, there was that whole debacle when the Treasury direction was issued, and it seemed to indicate that you had to get written consent to place people on furlough. That's been pulled back now, and actually under the existing furlough scheme, although under employment law, of course, you should get changes you should get consent to changes to terms and conditions. All the existing scheme says is to qualify for the grant, you have to have put in writing to the employee that they shouldn't carry out any work during the furlough period. Whereas the fact sheet that's been published, as I say, specifies that if you're looking to bring someone back to work on a flexible basis, so they're part furlough, part working, you must agree that flexible furloughing arrangement and you have to confirm that agreement in writing. So it seems to go a step further. It seems to require, and again, under employment law anyway, you're looking at changing terms and conditions if you're asking people to work part-time and furlough part-time. So if you're doing things properly, you should get agreement anyway, but it seems to be a requirement that you have to agree it and a requirement that you have to confirm that agreement in writing. And what is not clear to us at this stage is, does that mean the employer simply has to write to the employee to say, just to confirm we've agreed that you're going to return 3 days a week? Or is it more than that? Do you have to get the employee to then sign that to say, yes, I agree that that's the arrangement that's going to be put in place? I think it's just something for us to keep an eye on. What we can't decide, we've been talking about it in our team, and what we can't decide is it deliberate and the government are trying to kind of change the goalposts about where they realised they couldn't do it retrospectively for the existing scheme? Are they trying to make this scheme a bit tighter? Or is it just clumsy drafting in the fact sheet? And that's often been the case throughout the job retention scheme documentation that's produced, understandably, because it's getting done at such speed. So again, it's maybe a point, it's hopefully a point we'll get a bit more clarity on the 12th of June, but just to flag that issue to you. What else on the new scheme? Yes, helpfully, currently, as I said, employees have to be on furlough for a minimum period of 3 weeks at a time. From the 1st of July, the minimum period is just going to be a week at a time. So for those of you that are keen to rotate furlough, I think that gives you a lot more flexibility than you currently have. I know one of the issues that's often raised is that sense of unfairness between staff, those that are on furlough, those that are not on furlough. So there's more ability to rotate. But I'm going to have to give you a caveat on that, unfortunately, because the other thing the fact sheet states is that from the 1st of July onwards, when you put in your application for the grant, the number of employees that you're applying for cannot exceed the highest number that you applied for pre the 1st of July. Okay, so if we kind of work that through, let's imagine in March you put 20 staff on furlough, April 30, May 40, June 50. What that means is the maximum number of staff you can claim for under the new scheme for any month will be 50. Okay, so although I'm saying to you it's quite good because it gives you flexibility because it's 1 week at a time, so there's a possibility for more rotation there, you will still have to be careful if you're rotating more and if you're placing more people on furlough that it doesn't exceed the maximum number of people that you placed on furlough in any month prior to the 1st of July. Okay, so something just to keep an eye on. The other thing that's changed is that you, from the 1st of July, when you're claiming your furlough grant, your application cannot cover multiple months. Okay, so it has to cover July, August, September, October. You can't now put in applications that cover half of July, half of August, for example, which you can do currently under the current scheme. So again, from a practical point of view, it's just thinking about when your payroll runs, what would be the most appropriate time to put in your application, because it should only contain 1 month's claim at a time. There is a transitional provision there that says claims for June can be claimed right up to the end of July. Okay, so you do have that transition period there, but claims for July will have to be July, August, September, October, etc. Okay, so just quite a few things there I think to be aware of in terms of the new scheme. And then finally, just on amounts, this is a bit that I'm sure you will all have seen. I have to say I think it's more generous than I thought it was going to be. There was a lot of chatter up until Thursday last week that we were looking at employers having to contribute 40% and the government contributing 40%. And you'll have seen the figures. You know, furlough so far has cost the government £15 billion, which is a huge amount of money. I saw other figures published this morning that talk about a quarter of employers in the UK have furloughed staff. So, you know, it's a high number, and I thought it would go down quicker. However, what the Chancellor said on Friday is, right up until the end of October, all employees will have the same protection that are placed on furlough. So they'll always be entitled to 80% of their salary, plus the employer national insurance will be covered, plus the employee's pension contributions, the employer's pension contributions up to that cap will be covered. But what they're saying is, for July, things will stay the same. So employers will still be able to claim the 80% plus employer national insurance plus employer pension contributions. From August, employers will be expected to pay the national insurance and the pension contributions. The government will still pay the 80%. From September, the employer's contribution will increase to 10% plus pension plus national insurance, and the government will pick up 70%. And then finally in October, the employer contribution will go up to 20%, and the government will cover the remaining 60%. Okay, so just so that you're familiar with all of those amounts and you have those in your mind. The thing I was going to mention to you was, it was a question, we did a webinar yesterday, and it was one of the questions that came up around, so if you bring your staff back, do you have to pay them 100% for the days that they do come back to work, so they get the 80% for furlough time, or if you've topped it up, whatever you've agreed to, and they get 100% for the time that they're working, or can you reduce that to 80%? The answer to that is it's the same as any discussion with staff to change terms and conditions. You know, there might be businesses that are looking at it and thinking, well, we need staff back, but we're still not, we're still not providing services, we're still not having any income, so we need staff to come back on a lower salary. As long as you consult with your employees and you manage to reach agreement with them to reduce their salary, that's absolutely fine. So you could be in a situation where you say, right, you're on furlough 2 days getting 80%, and we've agreed that you'll come back 3 days, but we'll reduce your salary by 10%, 20%, whatever your staff are prepared to agree to. And obviously that'll very much be down to your own organisations and cash flow and what you need to achieve in relation to furlough. Okay. I've said 2 key dates for you so far, 12th of June, 10th of June. The third key date I'm going to mention to you is the 16th of June. Why is that relevant? Well, that is 45 days before the end of July. So if any of your organisations are thinking, well, you know what, we can keep staff on furlough until we start incurring costs ourselves at the beginning of August, we're not able to do that, and so we're potentially looking at redundancies. If you're looking at 100 or more redundancies, you've obviously got to do your collective consultation for a minimum period of 45 days. And so that 45-day period would commence on the 16th of June. So if any of you are looking at kind of business planning and that potentially being an option, have that date in mind. Of course, if it's potentially between 20 and 100 redundancies, that consultation period is reduced to 30 days. But just when you're starting to kind of think about the future and what your organisation might look like, and if there is potential for redundancies, then that 45 days is 16th of June that will commence. Okay. That's the key points on the job retention scheme. As I said, once we've got the more detail out on the 12th of June, I expect we'll be doing a kind of standalone employment webinar on that. I think we're trying to arrange to do one at the moment on the Tuesdays. That might be the 16th of June. So maybe another key date for your diary if you want to join that. The other point I was just going to mention though was the you might have seen some of the coverage. Well, you're maybe not all as sad as me and watched Boris Johnson at the liaison committee last week, but you might have seen some of the coverage that came out of the liaison committee last week, where Boris Johnson was asked about is it right that employers who are going to make staff redundant can place them on furlough, knowing that they're going to make them redundant. And the question was specifically in relation to BA. And what Boris Johnson said in response to that was, he wasn't prepared to talk about BA as an individual case, but he did think it was a very important issue that the government had to look at. And so it's this kind of sense of, well, why should organisations be taking government money for a period of time if the purpose of the scheme is to avoid redundancy, when they know that once the money runs out, they're just going to make the staff redundant anyway. Although my view on that is, when the scheme was first introduced, of course, employers had the ability, if they had already made people redundant, the scheme specifically allowed for you to bring those individuals back and put them on furlough in order to give them an income whilst we were going through this crisis. So I think originally when the scheme was introduced, the kind of view was it's not just about avoiding redundancies, it's also about avoiding mass redundancies at one time, but it may be that we just see a bit of a tightening up of the rules. And again, I think it's something we need to keep an eye on when we see the new rules issued on the 12th of June. To what extent are we starting to tighten up that scheme and restrict employers' ability to use furlough? Just something to keep an eye on. Just quickly pick up the question there from July. If we furlough someone for 2 days in the week and they work for 3 days part-time, can we claim HMRC grant for 2 days or 5 days? So you'd be claiming the HMRC grant for the 2 days only. So you can only claim the grant for the period of time that the employee is actually on furlough. Okay. For any days that they're back at work for you, you've got to pay them for the time that they're working with you. Okay. And just another question there, just so I'm clear, if someone is currently working but had previously been furloughed for more than 3 weeks, yeah, really good question. Can they then re-enter GRS after July? Yes, it's a really good question. You don't have to be on furlough as at the 30th of June to qualify from the 1st of July. You just have to have been on furlough at some point between March and June for a minimum period of 3 weeks in order to qualify for furlough from the beginning of July. All right, so that's you fully up to speed with the job retention scheme. Hopefully you've noted all those dates, you know what's going on, but of course the job retention scheme is not the only issue from an employment point of view in relation to COVID. The other issues that we need to be thinking about is the safe return of staff to the workplace, and what kind of plans you need to be putting in place there. So Lynn, be great. I mean, I know you've been advising a lot on this. If you can maybe chat us through some of the issues that employers need to be thinking about in order to make sure that there's a safe and secure workplace for their employers to return to.
Yeah, thanks, Morag, and welcome everyone. Some familiar faces, and as you said, we've been working quite intensely with some clients over the last few weeks, looking ahead to a return to work and having workplaces reopened. The coronavirus and looking at going back to work has left a lot of businesses really struggling to understand how they can ensure that they comply with their legal obligations, in particular their health and safety duties. The legislation for coronavirus was passed at record speed in response to the public health emergency and the threat of the virus. And guidance has been changing weekly, certainly in some cases daily, with regional variations now coming to the fore. So heads are literally spinning about what to do when it comes to compliance. The regulatory framework that is now in place to manage that public health threat that was created by the virus and provide enforcement powers is broadly similar across the UK. The general advice remains that if someone can work from home, they should continue to do so. But over the last week, 10 days, we've seen the UK and devolved governments, as you mentioned, set out the roadmaps and phases that are required in easing current COVID-19 restrictions. The emphasis across the board is very much on a gradual return to normal working life, although as you mentioned in relation to the employment sphere and the job retention scheme, we're seeing a slightly different pace down south than we are in Scotland. But very much the phases are dependent on the rate of the virus and infection remaining below minimum requirements and continuing to reduce. So we run the risk that if we see an increase or escalation in the virus, then we could be back to lockdown. And so, plans and the things that employers are needing to look at now need to take into account that contingency planning as well. Today, I'm just going to give a bit of a quick recap of the legal framework. It could be a session in itself, and we've covered some of this in more detail in previous webinars, and we're happy to look at in more detail going forward. But we'll have a look at, against that framework, what an employer's return to work plan should look like, and some of the main areas for consideration, including the implications of any accusation of breaching the regulations or your health and safety duties. And also just to mention those who are still working at home, which is a part of your workforce that should not be forgotten about at this time. So in relation to the legal framework, all employers have statutory duties to provide a safe place of work and general legal duties of care towards anyone who may be accessing or using their place of business. So your health and safety duties don't just extend to your employees, but that could be contractors and anyone who may be coming onto your site or using your place of business. There are a plethora of regulations and approved codes of practice which cover specific aspects of health and safety at work that I'm sure everybody is all familiar with. And breaches of health and safety duty are serious, they're criminal offences, and the penalties for failure to comply are not insignificant. Organisations could face unlimited fines, and where individuals are implicated and may have committed an offence, there's a possibility of imprisonment. Now, the new coronavirus legislation and regulations and public health guidance that's been issued operates in addition to and alongside those existing health and safety duties. The health and safety risks from COVID-19, as I'm sure we're all aware now, arise from person-to-person contact, transmission through close proximity with infected individuals, and surface transmission. So in planning a return to work, employers have to consider how to minimise those risks in relation to their business activities and safely manage the process of coming out of lockdown and returning to the workplace. The guidance isn't law. Unless it's actually stated as being mandatory, it is not law, but like other health and safety guidance is designed to assist in compliance with health and safety duties to ensure that you stay on the right side of the law and don't fall foul or breach the regulations and the general duties. But that available guidance must be considered along with other health and safety laws and regulations and any advice produced specifically for your sector or your industry body. Now, as we start to look ahead and plan to come into a new phase of living with this pandemic, there is now, much more guidance becoming available. The BSI has produced guidelines for working during the pandemic. The Health and Safety Executive has got a huge amount of very useful resources around all of this in relation to some of the steps that I'm just going to mention that you need to consider in your returning to work plan. And specific industry sectors such as construction, as I'm sure Chris might mention, are providing detailed guidance and assistance. It is slightly overwhelming. So today, I'm really going to distill that down into the 4 key things that you should be looking at in your return to work plan. But you need to avail yourself of the resources and be aware of any specific guidance that may relate to what you do and your business, as well as the general guidance. And that goes all the way up to the World Health Organization guidance in relation to the virus. So what should your return to work plan look like? Well, there really should be 4 key elements to that. The main principle and really the linchpin of your entire plan should be a COVID-19 risk assessment, which should consider the risks posed by the features of your business. And by that, I mean your premises, your operations, and your people in relation to the virus. And that risk assessment should then inform the steps that you as a business should be taking to minimize those risks. And as a lawyer, I would point out and bear in mind, you're only obliged legally to take you're not obliged legally to take every possible measure to eliminate the risk and the spread of COVID, only what is reasonably practicable. But that risk assessment process needs to inform those steps that you consider that you require to take. Following on from the risk assessment, you need to implement the measures that you have outlined are necessary to minimise the risks that you've identified. And in doing that, you may need to put in place, revise, or update policies, protocols, or procedures. And in that, I'm thinking you may need a COVID-19 policy or protocol on how you expect employees to behave to protect themselves and others while at work. You may need to monitor health and safety issues, including testing. And David Goodbrand is going to come on and outline some of the issues that employers may face around that. Because there are serious data protection issues around some of the testing and tracing options which are becoming available. You may need to update your sickness, health and safety or disciplinary policies, and you may want to consider establishing a register of employees to be able to keep a record of who may have contracted the virus, in particular where they perform a safety critical role in your business or a health and safety function such as a first aider or a fire marshal, and you may require to temporarily replace them if they become absent through contraction of the virus. You should also have in place a way to ensure that employees could make suggestions or recommendations about how you could improve things. And don't forget your home workers in relation to the policies and the procedures that you're putting in place. If home working is something that's new to you, then you may need to put in place a policy regarding home working. Out of sight should not be out of mind. You may have a significant part of your workforce who will remain working at home for some time, and employers have got the same health and safety duties to those who work at home as to the employees who are working in their place of business. So you may need to consider how you will keep in touch and monitor their well-being, what sort of work is being carried out and working hours, and any control measures that you may need to put in place to ensure their health and safety. So it's just something to bear in mind. And underlying the first 2 steps that I've mentioned there is communication, because that is going to be key in the success to your return to work plan. You'll need to consult. You have a statutory obligation to consult with employees, but you will also need to communicate with visitors who may be coming to your site, and you may need to institute training for employees on their return to work. So some of these measures may take a certain amount of resources, and they may take a certain amount of time. Certainly, as we're in the planning phase, you should be consulting with your employees about the risks in relation to COVID that you've identified and the steps and the measures that you are intending to put in place to ensure their health and safety on return to work. So online meetings about returning to work at the moment are something that if you've not already engaged in, you should certainly be thinking about. Um, and underneath all of that is an emphasis that this should be a dynamic process. So the fourth and final step in your return to work plan should ensure provision to monitor and review the processes, measures and procedures that you have in place. You may need to update in light of further government guidance. So those are really the four key aspects of any return to work plan. I don't have time to go into detail today on, specific aspects of risk assessment. I've alluded to the various guidance documents that are now being produced, but we're certainly helping clients and having really engaging discussions with clients around the suitability and sufficiency of their risk assessment process in relation to COVID, and also the measures that they may need to put in place to ensure that they comply with their duties. And that's against the backdrop of remembering that in the event of scrutiny from the regulator or challenge about your work practices, being in a position to provide a demonstrable audit trail of the risk assessment process that you have gone through and that the measures you have identified and implemented as being necessary to reduce the risk will put you in the best position to defend any claim in the event you are facing a potential breach of the regulations. And the threat in relation to that could be both internal and external. Your employees could effectively blow the whistle on unsafe practices, but you could also have regulatory inspections which could throw up concerns. And as coronavirus is now, and the risks associated with that are now reportable under RIDDOR, you could face yourself being subject to an investigation by the regulator. As I said, it's impossible to go into a lot of detail today, but more than happy to take any questions. And please do reach out and get in touch with us if you'd like more help on that.
Lynn, I'm conscious of time. I'm going to hand over to David just in a moment, but there's one question that's come in that I think really cuts across your world and my world, which is, what about employees who don't feel confident about the safeguards that have been put in work and, and they're kind of nervous about returning? And I suppose if I take that from an employment perspective first, and then if you've got comments to add on to it, employers will have to handle that very, very carefully. I mean, if there's any issue, if the individual is in any way suffering from a disability, for example, then obviously you've got your obligation to make reasonable adjustments, etc. But if it's more just the individual that's nervous about returning, obviously speaking to the employee, trying to reassure them, showing them what you've put in place, etc. But if the employee feels that they could be subject to, I think the phrase that's used, Lynn, is serious and imminent danger, is that right?
Yeah, that's right.
It's suddenly become phraseology that employment lawyers never spoke about before, but now we're all very interested in Section 44 and Section 100 of the Employment Rights Act.
Which sounds like a Jack Ryan movie.
It does, serious and imminent danger. But it gives employees particular protection. If they feel that they're at risk of serious and imminent danger, they can remove themselves from the workplace, and if they suffer a detriment as a result of that, they can bring a claim against the employer. So it is something that we have to be very, very careful about. I don't know, Lynn, if you've got anything to add to that.
I would agree with you. I think it's where the consultation process is really key. Because if you do your risk assessment properly and you plan properly and you consult with your employees, you're going to gain their trust and confidence. And you're entirely right at pointing out that employees have that right. But in addition, employees have their own duties under the health and safety legislation to cooperate with their employers and to ensure the health and safety of others that they work with while they're at work. Where it is becoming interesting, and this serious and imminent threat piece is something that I don't have the answer to, and I don't know if you do, Morag, is around the transport to work. Because obviously employers don't have any statutory legal responsibility in relation to employees getting to work, their commute. But given the significant risks associated with the virus and public transport, it's going to be interesting to see the extent to which employers either choose themselves to, or ultimately the courts may decide they should have taken into account the risks in the planning in relation to employees and their commute and travelling to work. So it goes back to what I've said initially, that the consultation and your risk assessment piece is really vital here, and making sure that you've got the support of your staff.
Yeah, brilliant. Thank you, Lynn. I'm going to hand over David. Lynn's obviously touched already on some of the issues around about employee testing and return to work. There's obviously massive data protection issues there that I know we've kind of touched on before, but I guess are starting to feel more real now for employers as individuals are returning. Could you just maybe pick up on some of those issues and what we should be thinking about there?
Sure, yeah, absolutely. So I think workplace testing is something that Lynn's alluded to that I think all businesses are now considering. And I think it's fair to say over the last wee while, compliance with data privacy regulations may not have been at the top of everyone's list of priorities over the last wee while, but I think particularly returning to work and workplace testing, that it can't be ignored now because it's very important to get it right for lots of different reasons, some of which Lynn's already mentioned. I mean, we've seen a lot of coverage over the last few weeks about the NHS's COVID Track app and the track and trace strategy generally. And there's been lots of questions about how much data is being captured, how long will the data be kept for what purposes will it be used, and who has access to that data. And I think employers are likely to face very similar questions from all employees where they're looking to conduct workplace testing, particularly things like temperature testing or such like. And obviously, you want to do that as part of creating a safe working environment for staff coming back into the workplace. But where you are testing and processing personal data and sensitive personal data, where it comes to people's health data, there are a number of data privacy considerations and questions. And I think just to echo what Lynn was saying, I think the key to all of this is to really be open, honest, and clear with staff about what you're doing and why you're doing it. I think if you can get buy-in at an early stage, I think that will alleviate some of the risks and concerns going forward. Helpfully, the ICO, the UK's data protection regulator, has issued some guidance on workplace testing. And it highlights that data protection law does not prevent you from taking the necessary steps to keep your staff and the public safe, but it does require you to be responsible with people's personal data and ensure that it is handled with care. So basically what they're saying here is, yes, data protection should not be a barrier to whatever it is you're doing, but you need to take forward testing in a meaningful and responsible way. So there's a few wee questions I think we need to maybe ask in relation to testing. First of all, what is the purpose of the testing and what lawful basis are you relying on for processing the test data? I think you need to consider, and more importantly, demonstrate that you've considered the overall purpose of the testing. What are you hoping to achieve? What are the benefits that you're looking to capture this data for? And lawful basis, what lawful basis are you relying on? Are you relying on people's togetherness spirit and consent to being tested, or are you looking at other lawful bases such as legitimate interests for your business? And you need to make and document your own assessment, and I think that sort of resonates with the risk impact assessments that Lynn was mentioning. Another question, what steps have you taken to ensure that the data collected is adequate, relevant, and limited to what is necessary? I mean, these are all really key principles of data protection law. And adequate, does the data achieve the necessary purpose? Relevant, is it relevant to the purpose? Don't collect irrelevant data. Is it necessary? Is it the minimum amount of data you're capturing and collecting necessary to achieve your aims? Don't go on a fishing trip to try and collect lots of data when it's not required, and actually you might get yourself into trouble because you need to be a lot more focused about what you're doing. And the third thing, I suppose, which a lot of employees are concerned about is who has access to my data and is it being held securely? Again, that real need to be clear, open and honest with staff as to who is actually having access to your data. And what that means is you need to update and look at your privacy notices, your privacy policies. What messages are you telling staff about what's actually happening here? To allay fears and to get buy-in at an early stage. And if it is to be shared with third parties, just making it clear who those third parties are, why they need to use it, and for what purposes. And I think a lot of us will probably, a lot of businesses will probably be looking to outsource the testing aspects to maybe third parties. So where you do have the third party in the chain, you as an employer are responsible for ensuring that you have necessary protections, contractual protections in place with those third-party suppliers to ensure that they are taking all necessary steps to minimize any data leakage or breach or such like. So all of these things, it's critical that you put in place a data privacy impact assessment to record your decision-making process on all of that. So what is a DPIA, a data privacy impact assessment? Basically, it's a record of the steps that you've taken to consider and mitigate and manage the overall impact on whether you're rolling out a new technology or a new process or a new way of doing things. And I think for all of us, it's going to be absolutely critical that we're focusing attention on having the right conversations at the right time, which is now, to think about the impact of privacy on our staff and everyone else that's entering our workplaces, and to be open, honest and transparent with everyone. I think it's interesting, a news article broke yesterday that the test and trace strategy of the government may not have passed a data privacy impact assessment as of yet. So it's kind of do as we say, not as we do. So that has massive implications in terms of people are being asked to give data about their people they've met, their family, their contacts, and all of this data is being collected. And it does seem rather odd that the overall impact of that strategy has not been assessed. But that's a kind of, I think, a reflection of the pace that everyone's moving at here. But you know, we are in a situation now where we are looking to move back into the workplace. And I don't think you can rely on the argument, oh, things are moving too fast. I think regulators have made it clear you need to assess everything now and don't turn a blind eye to some of these issues. Conscious of time, so I'm going to probably just wrap up there if that's okay, Morag.
Yeah, of course. I was going to say it's maybe quite similar to the employment law world, I guess, where these things are happening just now, but it's storing up for potential claims and issues in the future, sadly. But that's the reality, I think. So, okay. Thank you, David. Chris, I'm going to pass over to you just very briefly, if you don't mind, to talk about construction sites and where we're at with that now. It's an area that's obviously been in the headlines a lot. What is the position now there?
Thanks, Morag. Morning, everybody. Well, we've got very diverging approaches between England and Scotland, and that's been well publicised, and certainly the way that that relates to construction operations has been one of the more stark points of difference. In England, the pace has been a bit quicker, and construction workers are back on site working on a broad range of activities with health and safety mitigations in place, with social distancing, etc. In Scotland, we've got some significant construction-specific announcements made last week by the government here, and that followed up on the move into the first phase of that overall Scotland route map. Whilst significant construction work in non-essential sites should remain halted, and that's the non-essential sectors indicated by previous guidance, that overall route map says that during this phase, the wider construction sector can implement phases 0 to 2 of its own industry restart plan. So it's perhaps unfortunate from a clarity point of view that we have two related plans which are both split into phases, but careful attention is needed to keep track of that. That construction industry plan identifies phase 0, which is the planning phase, and that essentially covers off the various off-site activities which have been capable of being progressed throughout lockdown. And then phase 1 as the COVID-19 pre-start site prep, and that allows for largely COVID-specific mobilization tasks, such as installing social distancing measures on site. Other than those limited activities, there is going to be a further period of further consultation with government before the industry moves into phase 2 of its plan, which is identified as sort of soft start tasks on site, such as outdoor working, and that can only be where physical distancing can be maintained. That's anticipated by the guidance to be at least a fortnight away, and the remaining phases of the construction plan, which will restore greater normality, cannot begin until the overall Scottish plan moves into a further phase in the future. So that gradual easing is going to raise a lot of practical blockages, and one market example that we've already had is where a contractor has identified that even limited outdoor working for them is going to require certain other operations to be working, such as timber yards and supplies available, which currently are going to remain locked down, and that will mean that they're stuck. And it's because of examples like that that the Scottish Government's decision to not immediately sanction a move to phase 2 of the construction plan and a more flexible approach has come as a bit of a disappointment to a lot of people in the industry who've been diligently preparing for a return to site, recognizing the need to observe the social distancing criteria. So we've still got a long way to go before the blessing is given to full operation here. Obviously, we've got an awful lot of guidance here in Scotland which allows people to prepare, and attention here is remaining focused on contractual matters, what can be put in place before you go back to site. Alongside UK guidance, notably it's coronavirus guidance, which has been updated last week. And also the Construction Coronavirus Forum has put together some really detailed guidance called Safe Return and Restart on the approach to be taken. And that's got a lot of elements of more practical guidance and some precedent documents. Now, that's from a different body. It doesn't have the same official status. So contractors are treading carefully in choices about implementation of those measures. Obviously, guidance in general is not mandatory, as we've emphasized before. It's only those key health and safety steps that are enshrined in the regulations. So the decision to go back to work or not, and the impact on the construction contracts underneath those are remaining as a matter that has to be resolved by the relevant parties. We obviously see the government's guidance about acting fairly and in good place in resolving disputes, and public sector guidance about parties reaching agreement on how things are going to be dealt with based on reasonable claim headings. But we always have to bear in mind that if it comes down to a company's survival and chances in a dispute process versus those greater good arguments, the outcome is very uncertain. There certainly remains questions of who bears the cost of projects taking longer and costing more. Contracts will deal with that already, but they weren't put in place at a time that envisaged what COVID-19 might do. So clients really need to try and help to get an understanding of how courts are going to interpret and measure the provisions of a contract against what the government are suggesting is the accepted behaviour. So to what extent judges and adjudicators are going to react to that is going to be key. So just to summarise a few of the things we've been working on in the last couple of weeks, we've been advising on a few different approaches to assist in taking forward the steps to resolve the contractual positions. One of those relates to the issue that came out from the Chief Planning Officer earlier this week. That suggested that authorities should be pragmatic in allowing requests to extend working hours on construction sites, and it suggests that generally working hours might be extended from 7 a.m. through to 9 p.m. Monday to Saturday, with the certain exceptions that need to be put in place. Government is specifically said in that letter that they're not going to set a national standard. It still is authority to authority in terms of deciding that. And so in connection with that, we have been advising an employer client on a contractor's request to extend its working hours. And we've been taking care to try and make sure that we do that in a way that if the permitted working hours request is refused, the contractor doesn't automatically then get a claim under the contract for what's called an irrelevant event or irrelevant matter, which would lead to additional funds and time. So that's one of many areas where what it says in the guidance at the moment can lead to a knock-on effect on the contractual provisions, which need to be analysed and countered where necessary. For other clients, we're doing some advice on things called acceleration agreements, which are essentially a specific type of a variation agreement aimed at agreeing a new program goals whilst also settling existing COVID-related claims before you get back on site. And there's a blog from our team going to be coming out about that very shortly. A third line of current advice is looking at proposals to enter into some form of joint advisor appointment. So the advisor will advise both the employer and the contractor on an independent basis to determine the appropriate COVID time and cost relief. And that's based largely on the idea of having an independent certifier for your works. The intention is to move beyond that. Everyone should be reasonable suggestion in the guidance and try and find an acceptable way forward which removes the risk of ending up into a dispute when the parties disagree about what's reasonable and what isn't. So that's just a really quick summary. My team has their own webinar running on the 9th of June on construction issues. So if you are really interested, please do look out for that one and sign up to it. Thanks, Morag.
That's brilliant. Yeah, thanks, Chris. And yeah, obviously I think it would be helpful for people that have got an interest in construction side of things. That'll be a useful session to join, I imagine. So thank you for that. And finally, last but not least, Sophia, I'm conscious I'm making you all rush because I probably took up far too much time at the beginning because I find the job retention scheme so interesting. Last but not least, you're going to cover for us just some proposed changes to legislation in relation to insolvency and winding up.
Yes, I am.
Thank you.
So conscious of time, so I will get through this with you guys as quickly as I can, but you'll have to forgive me because I find it quite hard not to be quite effusive about this topic because it's an exciting time in insolvency law and we're seeing some really, really big changes to the regime, some permanent, some temporary, but also pretty important stuff. So by way of quick background, on the 20th of May 2020, the Corporate Insolvency and Governance Bill, another snappy title, was given its first reading at the House of Commons, and MPs are actually due to consider all stages of the bill today. There's going to be a few phases to go through the House of Commons and latterly the House of Lords before it receives royal assent, but for the purposes of this talk, it looks like it's not going to face much more amendment from its current form. And I say that as somebody who's a member of R3, which is a group that would lobby government in connection with changes to the insolvency law, and there's not a lot to be said to it. So I think what I'm about to talk about today, while not law at the moment, is certainly likely to be in the future and therefore very relevant. The purpose of the bill is to provide businesses with flexibility, to provide them with breathing space that they need to continue trading and avoid insolvency during this period of economic uncertainty. And it makes changes to a whole load of areas concerning corporate insolvency. There's far too many to cover in this 10-minute update. So I'm going to outline the changes of law around winding up and statutory demands, because I think those are probably going to be the things that businesses are going to be immediately most concerned with. Let me just very briefly let you know what the current position is in relation to winding up and statutory demands before I tell you what the changes are. So at the moment, if a creditor issues what is called a statutory demand, which is a written demand requiring payment of an unpaid debt that's worth over £750, and on the basis that it remains unpaid following that statutory demand for 21 days, or that it is not genuinely disputed on substantial grounds, that statutory demand can be used to support a winding up petition on the grounds that the debtor company is unable to pay its debts. So what that means is if I serve you with a statutory demand, it provides a way of establishing a company's inability to pay its debts. And importantly, it's also used often as an effective threat to elicit payment, or at least partial payment, or a payment plan from the debtor without actually going all the way to presenting a winding up petition. So what about the changes in the law then? What's happening there? The bill changes this. So if enacted, it's going to temporarily, completely prevent winding up proceedings being taken on the basis of a statutory demand. So it will void any statutory demand that's been issued against a company in the period between March 2020, so we're talking back a couple of months here, and the later of the 30th of June 2020, or 1 month after the bill comes into the effect, which is going to be around, let's say, beginning of June 2020. So the statutory demand that's issued in that time can't be used as a basis of a winding up petition at any point or after the 27th of April 2020. Now, the purpose of this is quite lofty. it's said to be able to give businesses the opportunity to reach realistic and fair agreements with creditors. Whether that actually happens is going to be a whole other case. So in short, a creditor can't use a statutory demand to threaten that a company will be wound up if it does not pay what's owed. And a statutory demand made in the relevant period will be void, and the creditor would have to find another way to demonstrate that the company can't pay its debt or is insolvent. So good for the debtor, not great for the creditor. The bill also prohibits creditors from bringing a winding up petition against a company on the grounds of an inability to pay debts during the period of 27th April to 30th of June, or 1 month after the bill comes into force, whichever is later, unless the creditor can demonstrate to the court that the company's inability to pay its debt was not caused by the coronavirus pandemic. And the onus is on the creditor to prove this if they do choose to present a winding up petition. So what this all concerns is, okay, put the statutory demand aside, is there any other way that I can present a winding up petition? Yes, maybe. You go to court and the court says, well, that's fine, but is the reason that they can't pay their debts or, because actually of the coronavirus pandemic? And then the onus is on you to say, no, it's not. It's not. They were independently in dire straits before this. Pretty difficult stuff there, and an untested area. So as you can see, the provision is again applying retrospectively from 27th April. So any order for winding up that's made from that date, but before the date on which the bill comes into force, may be subject to review. And if it transpires that the order was not one that the court would have made had the provisions of the bill been in force at the time, then the court will be regarded as having no power to make the order, and it will be treated as void. So pretty far-reaching retrospective effects there. And in those circumstances, the court, again, has been given a pretty big discretion to give directions as it thinks fit for the purposes of restoring the company to the position it was in before the petition was presented. So to wrap up, because I said I'd rattle through this, this piece of the bill is interesting. It's probably going to cause some significant practical difficulty because it could cause a lot of litigation if you wanted to. For example, it's going to be very difficult for a creditor to show that a debtor's inability to pay debts was not linked to coronavirus. I mean, you're going to really have to enter into a forensic analysis on that, and it's open to interpretation. There's also still a number of petitions for winding up, certainly going through the Scottish courts, and I specialise in English law as well as Scottish law, and it's certainly the case that the English courts have continued to facilitate winding up. So these issues are very real. And, just thinking outside the box as well, there's a bit of a question as whether this approach is actually robbing Peter to pay Paul.
That was the question I was going to ask. I'm conscious of time, that's 12 minutes, probably you can finish up now, but it does feel a bit like that, doesn't it? It's kind of, it's a domino effect, really, isn't it?
Of course it is. I mean, it depends on, the vulnerability of the creditor that's not being paid. Yeah, I mean, the domino effect is the creditor isn't being paid by the debtor who's being protected, may then in turn become a debtor itself. So, while the objective of the legislation is meritorious, you've got to wonder if it's going to contribute or harm the country's economy in the long term. But as I said, in the short, it gives debtors reprieve and requires creditors to be patient. What I do think is very important, though, and this was a bit of practical advice to get both creditors and debtors through this period, is to enter into a dialogue. Because you're better off in these circumstances with a payment plan and a partial payment than or an agreed delay on the period than adopting an incredibly antagonistic approach, which might have served you well in the past. So, food for thought.
Brilliant.
Don't stress if you either get a statutory demand or feel like you have to issue one. There are ways around it all.
That's brilliant. I I don't think I've ever seen someone get so excited about insolvency law, Sophia.
I can't help it. Our act is from 1986. This is probably the most exciting thing that's happened in decades.
Yeah, quite. Listen, thank you to all of the speakers. I hope you found that helpful. I'm conscious we've run a couple of minutes over, but hopefully you can head off for your lunch now, Alan. I hope you get your order delivered. And well, I imagine we'll have another session probably in 2 or 3 weeks' time as things develop further. And as always, if you've got any questions, please do just get in touch with us. Really delighted to help if we can. All right, take care, everyone. Thank you.
Thanks.
Thanks, Morag.